Thank you, Ceann Comhairle. Minister, last Friday a landmark judgment in Cork involving Cork County Council versus the Minister, the Attorney General and the planning regulator laid bare the rot that exists at the heart of the planning system. May I preface my remarks by saying this is not a criticism of the office of the planning regulator, as distinct from the manner in which the current office holder has made recommendations to your office. That displays a fundamental lack of understanding of the relevant planning law. The action of the Minister to reverse the decision of Cork County Council on foot of the advice of the regulator was a notion that would offend a first-year law student. Ceann Comhairle, Cork County Council had no alternative but to judicially review the decision of the Minister. The point to be decided was one that had been decided more times than most law students care to forget. This case should never have darkened the door of the courthouse. The judgment confirmed that so many other judgments had confirmed previously. Local authorities must have regard to general ministerial guidelines. They are not required to follow them slavishly. It was implied by the regulator that these guidelines were mandatory. Knowing this was wrong was the equivalent of knowing that 1 + 1 = 2. Justice Humphreys filleted the office of the planning regulator and the department. Eminent planning senior counsel has described this planning judgment as one of the most accurate and scathing he has seen. What is striking about the judgment is the frustration of the judge at the obvious, fundamental lack of knowledge of the planning regulator of the basic principles of planning law. Issues with your planning policy department are not new. For example, Minister, I have put PQs on planning to your department, and the answer I received was intentionally, Jesuitically misleading. Subsequently, Wexford's County Manager's Report relied unlawfully on that answer to recommend an unlawful, inappropriate measure to our councillors in County Wexford. We can no longer, on the basis of this judgment, trust the response that TDs in this House receive from the planning section of your department. We can no longer have confidence in your Assistant Secretary, who is responsible for planning policy, whom allowed you, as Minister, pursue an unlawful attempt to reverse the decision of the elected members of Cork County Council. We can no longer have confidence in the planning regulator. As Judge Humphreys pointed out at paragraph 70 of his judgment, the basic lack of legal knowledge displayed would have been sufficient grounds for the judicial review. You are now on notice, Minister, that you have a very significant problem in both the office of the planning regulator and in your planning policy section. It is clear that the head of the office of the planning regulator has not got the legal planning knowledge or the skill set to maintain his position. He has had his homework corrected by the High Court, and he received an NG. The defence offered by him is that this case was the equivalent of "the dog ate my homework." The regulator occupies a quasi-legal position, and his continuing in his current position undermines the office of the planning regulator and the performance of its functions, and it removes certainty from the planning system generally. It is with regret that I say the planning regulator is not fit for his position. You must appoint somebody who has the skill set for the position, and I fear if you don't, the contamination effect may reach your office. Minister, as a result of this landmark judgment, the question arises: who regulates the regulator? Quis custodiae, ipsos custodies. Can you make a statement, please?
For the record, I would not normally allow some of the statements to be made that have been made, but I'm very conscious that the Deputy is extrapolating from the decision of an eminent justice, and that decision has already been in the public arena. Minister.
Thank you, Ceann Comhairle, and I would also point out that it is still before the courts potentially, so I'm very much precluded in terms of what I can say in terms of the specifics to the case. But I will reply in fact In the first instance, I would like to set out from the outset that my role as Minister in relation to the planning system is primarily to provide policy and a legislative framework under which planning authorities, the Office of the Planning Regulator and on Board Pleanála perform their statutory functions. The legislative framework chiefly comprises the Planning and Development Act 2000 as amended and the Planning and Development Regulations 2001 as amended. As members of the Oireachtas, we debate and introduce legislation which the OPR then enforces. As we are elected by our peers and citizens of this state, I think the primacy of members of Dáil Éireann is appropriate. Recommendation 10 of the final report of the Mahon Tribunal recommended the establishment of an independent planning regulator, which led to the establishment of the Office of the Planning Regulator on the 3rd of April 2019. The Deputy will be aware of the outcome of the report of the Mahon Tribunal and the corruption which we have now tackled that existed around our planning system. Other recommendations included the introduction of a register of lobbyists, limitations on political donations and a stronger whistleblower legislation. While I cannot comment particular aspects of the judgments, on which is open still for the State to appeal, I wish to emphasise the importance and the role of the OPR as part of ensuring that the effective implementation of the plan-making process. Ultimately, where the OPR considers aspects of a plan do not conform with national or regional policies or proper planning and sustainable development, the regulator issues a notice to the Minister recommending the powers of a ministerial direction be engaged. The decision on whether to issue direction is ultimately a matter for the Minister, and there are safeguards reflected in the legislation in relation to the accountability of the Minister to the Oireachtas. This is critically important underpinning of a plan-led approach followed on from the Mahon Tribunal. In accordance with the Code of Practice for Governance of State Bodies, the Department has an oversight agreement with the OPR, the purpose of which is to ensure clear service ownership, accountability, roles and responsibilities of both the Department and the OPR with a view to ensuring that the OPR is discharging statutory functions in an efficient and effective manner that commensurate with resources allocated to it and enable it to discharge those functions. The agreement identifies the distinctive roles of both organisations, their mutual commitments and expectations, and provide the basis for ongoing engagement between them. I am satisfied that there are good arrangements in place in terms of accountability to the Oireachtas and governance in the Office of the Planning Regulator, and we continue to keep legislative provisions under review, particularly in the context of the planning review currently being led by the Attorney-General, which is due to report in September next year in terms of a fitness test for the whole planning legislation, and any legislation required on foot of that review will be enacted before the end of the year, which is a very ambitious target in terms of the complexities of the planning system, which, I may add, processes 27,000 applications per annum, only 10% of which is appealed. Just want to make two further points. The planning regulator has a job to implement and be guardian over a plan-led system that this Oireachtas has approved, having a shared vision right down from our national planning framework right down to our local plans. I think the planning regulator and the current occupant of that office is a highly professional individual that discharges his functions on a daily basis with considerable thought, with considerable merit, and does not take any decision lightly in terms of to recommend a direction ultimately to the Minister, who decides in relation to the Oireachtas. Secondly, I would say in relation to the Assistant Secretary of our Planning in our department, a very highly respected individual who has done huge work and given huge service to the state. And I had the privilege of being in your county, in County Wexford recently, seeing the leadership that Tom Enright is giving there, the Chief Executive. Many innovative projects which I have not seen in other local authorities in terms of future-proofing employment, key infrastructure being delivered in County Wexford, bringing massive jobs into the county. And I think the work that the Executive are doing and the councillors in underpinning those policy decisions, taking hard decisions in terms of revenue-raising mechanisms, is exemplary.
The headlines when the Mahon Tribunal was completed and the creation of the Planning Regulator's Office was announced, and I quote, "New regulator will restore confidence in planning system." Now, my opening remarks I prefaced by saying that this is not a criticism of the Office of the Planning Regulator, as distinct from the manner in which the current office holder is discharging his duties. There was a basic failure by the Planning Regulator and your office to properly establish and consider the established law in the area. The law is not the issue here. It's the lack of understanding of those who are supposed to understand it. And I can assure you that a second-year law student, if faced with the straightforward question of what is the established law and precedent in relation to Section 28 ministerial guidelines and Section 31 ministerial directives, would revert in 20 minutes with the unequivocal answer, there are 2 High Court cases that clearly establish the following. In case you're thinking of appealing, Minister, I'll quote them for you. Ministerial guidelines are not prescriptive or mandatory, based on the decision in Brophy versus On Board Pleanála 2015. And 2, Section 31 of the 2000 Act does not entitle the Minister to impose by direction his own views in relation to the proper planning and development of the area over those who are elected members of a planning authority, based on a decision in Trister versus the Minister for the Environment 2010. Now, can you explain the rationale and motivation for proceeding with the Section 31 directive when both you and the planning regulator were aware of the case law, and if you were not, you most certainly should have been? The question, Minister, that I asked originally was who regulates the regulator? Well, the answer, Minister, is it is you, and I think you should do your job for the sake of the county development plans being put together in this country to save the rest of us from judicial review proceedings to no end because of a basic lack of knowledge by the current sitting planning regulator in advising you incorrectly. Thank you, Count Corley.
Now, the Minister is precluded from discussing any individual planning case, but the generality of the issues are in order.
Thank you, Count Corley. And we've heard a number of sound bites from the Deputy in question, which should guarantee a few clips in social media and will guarantee potentially some regional radio. But I've seen no substance. I have seen no Excuse me,
You're
Count Corley.
spending the taxpayers' money frivolously.
Minister, without interruption.
I have listened for the last 5 minutes of a deputy come in here and take the name of a number of highly respected public officials that have given huge service to this state. I want to make that point very clearly. I robustly defend their actions, and I know for a fact how hard they work and how well they are doing in their role and the job that they are doing. And I think if you have read the OPR's report, his annual report, the detail in which he explains planning decisions taken right throughout this country is exemplary. I want to make a number of points. In the first instance, the safeguards are built into the system through the primacy of the Oireachtas. We hold the planning regulator to account in terms of the Minister deciding or not to pursue a direction or recommendation that's issued to him. In any case, we have to take all the factors into consideration. In the second instance, I want to make very clear that our county development plan process is working well. In general, councils are passing all their county development plans, meeting their obligations at foot of same, and under the national planning framework there is significant capacity in terms of housing delivery right across the 31 local authority network. 9 local authorities have to increase their housing delivery by 100%. There's around 13 that have to go by over 250%. So there's huge capacity for us to build on the opportunity that was of the crisis of COVID-19. And I can say for sure, we had at one stage in this country a system that had enough zone land to cater for an additional 10 million people in this state, zoned everywhere with no correct infrastructure to underpin that development. The Office of the Planning Regulator, now through the plans we have put in place, a plan-led system, this Oireachtas, is a guardian to ensure we never go back to that day again and that the right development takes place in the right place. And I am proud of the work of the OPR and my department in ensuring that, and nothing backs up assertions like fact. 27,000 planning permissions approved in this state every year.
We go to the